Collaborative law is a relatively new method of dispute resolution, particularly in family law, where that parties must agree to use, and it is defined by a participation agreement. Both parties sign and both of their attorneys sign. That basically says, under no circumstances are we going to have anyone other than us decide or resolve any of our disputes, that we will set about resolving usually a divorce through interest-based negotiation. We each agree to provide all information to the other party that we know they need, whether they ask for it or not. So there is a duty of disclosure without having the information requested. You exchange information. You may prepare a joint listing of property, or one party might prepare it, but you identify then all the issues that need to be resolved in order to restructure this family. Okay, because and even when there aren't children, there are other relationships that may be ongoing for those parties, but basically helping them restructure the rest of their life, so that we then have a series of meetings, joint meetings. We may use other services of other professionals, frequently communications coaches, to assist us in the positive type of communication that's necessary at these meetings to get to a resolution based on everybody's needs and desires. If there are children involved, children's experts are consulted about what the best plan is for these kids. And if there are other areas of expertise, such as a business to be valued or a piece of real estate to be appraised, we can jointly hire appraisers or other experts, rather than having what in litigation ends up being the sort of dueling expert, hired guns. So it's a much more positive a way of going about resolving the most important case that most people ever have in their whole life.